This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about grandpa in the law. As we get older, we start worrying about senior members of our family, and if something happens to them, what's going to happen to their assets? Will they go to the right people? Our own assets. If something happened to us, will our assets go to the place we want them to? So tonight's your chance to ask those questions about wills, powers of attorney, retirement planning, but also nursing home negligence kind of questions. If you've got questions, call in the 31 Law Call number 256-536-0077. We'll also have some of your email questions, and you can email a question on any legal topic. You send it any day of the week to lawcall@waytv.com. And when we get to a show that's on point, we pull out some of your email questions, and we are going to have some of your email questions tonight. Will League is here from Timberlake and League. Good to have you here.
All right, Sharon, how are you?
Doing well. We've got tonight's You Make the Law Call video. Now this, if you're an antique car lover, this is going to make you sad, and I love beautiful old cars. But check this out. This is courtesy of YouTube. You may want to look away if you love these old kind of cars. So an old car, look at the difference between a vintage old car and a modern car that's got airbags and seat belts and all the safety features. So Timberlake and League, you deal with personal injury cases all the time. Can you tell a big difference between a modern car that's got everything in an accident versus an older car?
Well, Sharon, it's kind of counterintuitive. You feel like a heavy car such as this would have a little more protection because they were made of steel,
yeah, you're
and
driving
metal,
a tank,
and all that
right?
kind of stuff.
Isn't that what everybody always
so
said?
That was kind of what you thought, and some people put their teenage daughters, sons in bigger cars for protection. However, even with all the steel, the safety devices and technology have just far surpassed. We're talking about a lighter car versus a heavy steel car. In a lighter car, the occupants are much more safe. And so when you're looking at products liability, you're looking at the Alabama Extended Manufacturer's Liability Doctrine, which basically did, Ford, GM, anybody place a car in the stream of commerce that had a poor design, faulty design, and was unsafe for its intended particular purpose. And so, again, it's counterintuitive, but the lighter, more modern car won that battle. The occupants came out with less injuries. And so, yes, we look at products liability cases. You've heard of Takata airbags. Everybody's heard of the Pinto, the Bronco 2s for the rollovers. And if a company places a product in the stream of commerce that's unreasonably dangerous or defective, or is a design that's not up to the industry standard, there could be a products liability claim. And that must be balanced with, when you're taking on GM, Ford, all of the big boys, your injuries or damages have to be such that it is worth taking on those companies. So oftentimes, we're telling clients that there's an economic reason why you shouldn't. Let's say you spent $50,000, $100,000 to pursue the claim, and your claim was only worth 10. So you're kind of economically out of it. However, some of the cases we've dealt with, Takata airbags, some of the horrific injuries and death, then we'll take on the big companies for defect in design, manufacturing, and placing that dangerous product in the stream of commerce. But tonight we're talking about a very complicated topic, death and taxes. We're all going to get older. It's going to happen. But what to do when your loved one starts to become older? Do you have a will in place? People, trusts are all the rage. Sometimes the trust can get out of control. Will Medicare, Medicaid, when you go into a nursing home, oftentimes you go into Medicaid. How do you spend down those assets to qualify for Medicaid? Because again, nursing homes can cost $5,000 to $15,000 a month.
Ooh,
and so then it takes away your loved one's nest egg, and then they're dependent on Medicaid. So what are the issues surrounding that? And we'll get calls about that, and we call the expert Connie Glass, who is one of the best elder lawyers I know. She's the go-to when we have a difficult question. Connie, the typical question we get is, mom's getting older, she can't drive anymore, she wants to stay in her home, and what should we do? And I ask a series of questions, and then I usually call you. What do you tell those folks?
Well, there's, of course, ways to keep mom at home. If that's a goal of the family, for mom to remain in the home, there are caregivers that you can hire to come into the home. There's not government assistance very often for those programs, but there are private caregivers if someone has long-term care insurance that'll pay for in-home caregivers. But moving to the next level of care, perhaps assisted living, before the person would need nursing home care, assisted living is a great option. And then finally, when the person needs 24-hour nursing care, then the option is to go on into skilled nursing. The skilled nursing facility is the one that you had mentioned that costs so much, and that's when people begin to have to liquidate assets to pay for that kind of care.
What about some of these insurance policies you hear about long-term care? And we talked a little bit about the show about reverse mortgages. So to qualify for Medicaid, what are the asset requirements? And that usually gets people freaked out about, okay, Medicaid's coming in, they need to take my house, my bank accounts, everything I have, and now I'm kind of I'm held hostage by Medicaid and the government. There is no control.
Well, that is not what happens.
Okay.
It's what people think happens, of course. It's what we hear. But Medicaid doesn't take anything. When you enter a nursing home, your obligation to a nursing home is to write a check once a month and pay for your care. If you have a long-term care insurance policy, you had referred to that, then the long-term care insurance can write the check to the facility each month, depending on the amount of coverage you have with your policy. If you don't have insurance and you don't have sufficient income to pay the nursing home, perhaps the nursing home is $8,000 a month and you don't have $8,000 coming in, then you have to begin to tap into your resources. And if you're a single person, you have to spend those resources down to no more than $2,000 in total resources until those are gone, at which point then you can apply for Medicaid assistance. If you qualify for Medicaid, then you contribute your income to the nursing home, and Medicaid actually pays the nursing home the difference. So Medicaid's not taking things, they're actually writing a check to the nursing home for you once you qualify for that program.
So what are we talking about? Advising people in advance to do certain things with assets well in advance of needing to go into nursing home care to save those assets. What are you talking about in that circumstance?
Well, the only option for saving assets is to divest yourself of those assets, or to buy long-term care insurance, like Will mentioned earlier. If you don't want assets to count as being available to you when you enter a nursing home, they have to be out of your control, beyond your reach, for more than 5 years before you apply for Medicaid assistance. Medicaid will look back in your history for 60 months, for 5 years when you apply. What they're looking for is to see if you've given away or transferred anything for less than its value, made a gift. If you have, then Medicaid would add up those transfers and gifts, and then they will not pay for your care for as long as those assets would have lasted you.
Gotcha.
Connie, what's the instrument? Let's say you're planning perfectly and you start 5 years prior, and it just so happens mom or dad needs skilled nursing care on year 5. We talking about a trust, or are you talking, can those assets benefit mom or dad? Or
No.
You said they have to be out of their control, and that's terrifying to spend down to $2,000.
Yes, many people choose not to divest themselves of assets. That's a pretty scary thing, that you're giving everything away, essentially attempting to qualify for a nursing home benefit sometime in the next after 5 years. So many people, once they find out that there's nothing magic where they can keep the assets and control them and use them, and then magically they don't count if somebody goes to the nursing home. There's just not a tool to make that happen.
Okay, we've got callers waiting. Jane is on the line with a question from Athens. Hi, Jane. Thanks for calling. What's your question tonight?
Oh, you're welcome. My question is, I'm divorced, but I had took out insurance on my ex-husband when the children were real small, and I put myself down as beneficial at the time. Will that money still become to me, or do I gotta get someone else to benefit for it?
What type of insurance policy was it, Jane?
It's life insurance, hon. He was in an accident when the kids were real young. I said, Lord, something happens, we can't take care of one another, so that's the reason I took it out.
Well, if you've got a life insurance on him and you're the beneficiary, you paid the policy, and it depends, you have to go back and look into that policy to see who has the authority to change the beneficiary. And if you're still a beneficiary, then that money would come to you, unless in that policy he, as the insured, has the ability to change the beneficiary. Even though you guys are divorced, it matters not. If you're the beneficiary, premiums have been paid, and you would be able to receive those funds. But you need to go back and make sure who had the authority and power to change that beneficiary.
They're telling us take a break. Let's take a break. We'll be right back answering more of your questions about grandpa and the law. We're talking about wills, trust, estate planning kind of questions tonight.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back. Will League is here from Timberlake and League, and got a special guest down there with you that sometimes goes out on the lake.
That's right. She goes everywhere with us. Kids love her. I didn't want a dog, and I'm crazy about her.
This is Lakin.
This is Lakin. That's right. She came up a few weeks ago, and we have a little video with her on here. We were on the boat, and we were deciding that we're going to take Lakin surfing, and this is a failed attempt, and then some almost drop her.
You're kidding. Does Lakin enjoy this?
Well, she had a ball. Now
Look
I
at
must
you.
admit. So here she is.
Oh my stars! Fantastic, fantastic.
Yeah, so
that
she's
is too cute.
She goes everywhere with us, and
and you didn't want a dog.
I didn't even want a dog. Now I must say she's got a life jacket. Now she forgot to put it on.
Yeah, she should have that on.
She should have her life jacket on, and we're working on her memory. So yeah, that was just right around the corner in Gunnersville Lake, and then so Lakin came up to Law Line with us tonight.
Fun.
So
Connie Glass is with us tonight too, answering questions on elder law, estate planning kind of questions. One of the things we just touched off with, Jane had the question before that she was asking about life insurance things, and so long as Jane is the one that's paying for the policy when her husband, even if it's the ex-husband passes away, she can collect. But Connie, if she's not the one paying for the policy, it kind of changes things.
Right. The law, there's a law that states that in a divorce, unless it's addressed, of course, in the divorce decree, that if the ex is not paying the premiums, the beneficiary is not paying the premiums, then the divorce voids that beneficiary designation.
So who does it go to? So
it will go to the next beneficiary if there's one named as the successor. If there's not, it would go to the estate of the deceased person.
Gotcha. And then what happens with it?
Then it would pass through the will of the deceased person, if there is one, and if not, then it would pass by the laws of intestacy. Basically, the Alabama legislature's written a will for you if you choose not to do it yourself. So.
Connie, got a question about trusts. All right, so they were all the rage for a while. So I know limited about it, but when I handle a case, oftentimes we'll need to create a trust, whether it's a minor or someone that's getting a lot of assets and needs help managing those assets. Sometimes it's long-term health care. Sometimes they're children whose parents have passed, and we set up trusts and things. But in the estate arena, now those assets pass outside the estate, and you avoid probate.
Correct.
And the ones that we've administered here recently, sometimes we've had good luck with the trustees, and it's smooth as silk, and sometimes it's a nightmare.
Somebody not so good. Right?
What do you tell clients when they're considering a trust with the benefits of passing outside the estate, or doing the traditional route, getting a will when they perish, submitting that to probate, and going through that process?
There are many different kinds of wills. You've alluded to several different types. What I tell my clients when they come to talk about a trust is they've usually either read something on the internet or they've been to somebody's talk about trusts. But basically, you need to do a trust with a purpose. If it's for a minor, if it's for a disabled person, if it's for someone who needs management because they have a drug or alcohol addiction. Just to do a trust because everybody does a trust is not a good reason to do a trust. So the choice of the trustee is the most key issue in all of this, because the trustee has control of those assets according to the terms of the trust. If the trustee mismanages the assets, then it may be that the beneficiaries don't find out about it until it's too late.
Right.
So choosing that trustee is critical.
We got this email question in from Chris. Chris had written in, my dad's getting unable to take care of himself. Are there some different kinds of powers of attorney depending on whether I need to assist with medical decisions or financial decisions? Because I'm just not sure where to start. What would you direct on that?
Absolutely. The a power of attorney only allows the agent to do what the power of attorney states the agent can do. So many people come to me with financial powers of attorney just assuming the agent also has power to make medical decisions. Again, if the power is not listed within the document, you don't have that power. There's a new statutory form that the legislature created a few years ago. A lot of people are using that one. There's a section about allowing the agent to create trusts that many people choose not to initial. So if a person needs a trust that, for example, that Will mentioned earlier, perhaps they're going into a nursing home and there needs to be a trust set up, an income trust or a pool trust to manage assets to cover things that Medicaid doesn't cover. There's all kinds of trusts you can use for that purpose. If the power of attorney doesn't allow the agent to do that, then we're still going to have to go to court to get that authority. So you need to know what your power of attorney says. Don't just assume that they can do anything. The powers have to be listed.
And when you go talk to a lawyer about setting up someone like Connie, you want to make sure that you've got your will or the trust, you've got a medical advance directive, and you've got a power of attorney to talk about, be able to make financial decisions for you, and they're basically in your shoes unless you revoke it. Sometimes they're irrevocable power of attorney, but make sure that you've got all of those instruments when you go in and sit down. And your lawyer will talk to you about that. And it's, we're all going to get sick and we'll need help at some point, and you need to designate someone to make those decisions for you if you can't make them. And it's a difficult decision to make, but it's going to happen for all of us.
We've got another Jane. Jane from Henniger is on the line. Jane, thanks for calling. What's your question tonight?
Yes, I have everything we have has been designated to my son. We have an irrevocable trust.
Okay.
And I was just wondering if that you have to have it for 5 years?
So Connie, what's the 5-year rule there? What has she got, and how does she know if it's going to do what she wants it to do?
I don't know what you have. I heard you say that you have an irrevocable trust.
Right.
Just the simple fact that it's irrevocable doesn't mean that it may not be countable if you go to a nursing home. If you have an irrevocable trust, if you've created one, put your assets into it, and you're not the trustee, and the assets cannot be used for you, then that's subject to that 5-year look back. You create it today. If you don't go to a nursing home for 6 years, then those assets don't count. But if you've created an irrevocable trust and you can use the trust, the assets can be spent for you for your health needs, your personal needs, whatever you need, then you've not done anything of transferring those assets beyond your control.
So does the 5-year window even start?
It doesn't, because you've not given anything away.
So if you receive any, and a lot of people out there are thinking, okay, she started a trust, it was 5 years ago. What if son uses some of that money to benefit her? If you're caught doing that, then all that money is counted before you qualify for Medicaid to help you with the nursing home bill. Is that accurate?
It's what the trust states. If the trust states that the trustee can use those assets for the benefit of the person whose assets they were. So if Jane created the trust, put her son in charge of the trust, and the trust says, son can use those assets for any purpose that Jane needs, for her health support, maintenance, whatever she needs, then the assets are available to her. Putting them in the trust did not make them beyond her control and use.
Gotcha. Okay. We've got Juanita on the line with a question from Fayetteville, Tennessee. Hi, Juanita. Thanks for calling. What's your question tonight?
Yes, what I was wanting to ask about is my mom had passed away a few months ago.
Okay, I'm sorry.
And it's 3 of us children left, and she didn't leave our name, nobody's name on the deed to the house. we want to try to find out what we need to do or how we need to do that.
Juanita, did she have a will?
No.
Okay. And so without a will, she would die intestate, meaning without a will, and it goes by the laws of intestate succession. Was she married?
Yes.
Okay. And was her husband, is he still living?
He's deceased as well.
Okay. And she has children, 3 of you guys with your father, correct?
Yes.
Okay. And so basically it would go down in laws of intestate succession. If her husband was alive, there would X amount go to him and then split with the children. Given that he has already predeceased her, then those assets, the deed to the house or the house itself, would pass down to you 3 based on the laws of intestate succession. You need to go and sit down with a lawyer, and you want to get some things filed to go ahead and start that process to have whatever assets she had passed down to you guys by intestate succession. Connie, what's the first step for her? There's no will, there's some assets. How does she go and file to start this process?
I noticed you were calling from Tennessee. If your mom died in Tennessee, then you would need to contact an attorney in Tennessee so that process can happen in the state where she was a resident. You would do an estate administration. If she died in Alabama, then you would do it here. If she died in Alabama and all the children live in Tennessee, then none of you can be in charge of her estate, because with an intestate estate, the Alabama courts can only appoint an Alabama resident.
So it's not the end of the world, her not having a will. There's ways to get it sorted out, but it will be a process.
Correct.
Sure will.
Connie, if her mom had wanted to do a will, can you hire attorneys from across state lines to draft the will? Would it matter if she came to somebody in the state of Alabama to draft it?
No, it would matter. She needs to choose somebody who's licensed in the state where she resided. Now, there are some attorneys here in Alabama, particularly in North Alabama, who are also licensed in Tennessee.
Okay, let's take a break. Be right back answering more of your questions about Grandpa and the law. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Connie Glass with the Elder Law Firm out of Huntsville, 256-536-9494. Also check out elderlawfirm.net. Here's how to get in touch with Will League with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. They do personal injury cases, so everything from car accidents to medical malpractice. Check out law-injury.com.
And for family law attorney Sharon Doviet, Huntsville, 539-7337, SharonFamilyLaw.com. You know, family custody, child custody, things like that, it gets crazy on those things. It sure does. And when you're talking about the end of life decisions, you need a will, advance directive, power of attorney, all those things. You need to talk to an attorney similar to Connie Glass in the Elder Law Firm. And good luck. Appreciate you calling in tonight. And Lakin's, you got bored with Elder
Chilled
Law.
out.
Yeah.
Thanks for all your questions
Lakin
tonight,
can
everybody.
always be here with me.
Such a sweetie. Good night, everybody.